Hey guys, it's Kathy. How are you? So, I worked hard yesterday and today on my microphone. I got a new one, but I'm not still not happy with it. So, I did a thing, and I got in trouble for it. I ordered another microphone, and it was real expensive. And so I'm a single mom. So all my pennies over the years just go to my kids. My pennies go to my kids. So late the other night, I was online and I saw this real expensive microphone and I thought, what the heck? And I bought it, forgetting that all of my tracking information and notifications, everything like that, they just automatically just go to my kids because nothing is ever for me. I cut my own hair. I eat peanut butter and jelly. Everything goes to them. So as soon as I ordered this real expensive microphone, um, my kids came in and they were like, "Mom, we're hacked. Someone's ordering stuff from our account." Our account. Our account. Like they help pay for it. No, 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 they don't. It's my account. And if I want to buy a microphone, I can. Okay, that's not true. And now I'm crushed with guilt for spending all that money on myself. But I did it. It's not in yet. So we're gonna have to limp by with this one, but I think I got this one going the best that I could possibly get it. Um, and I think I found some court videos that, the audio is not terrible. Some of them might be a little sketchy, but they're good. They're really good, and you're missing out if you can't be bothered with a little bit of bad audio in a courtroom, because that's just the way courtrooms are. Um, I also did one thing this video that I don't normally do. I went through the big guys. So we have Manning, who is my absolute favorite judge, and then we have Simpson, we have Middleton, we have Webster, we have all those, and I try not to touch them too much because you guys get to see them from so many other people, and they're excellent. Law Talk with Mike and Biggin and Old Squishy Gardner, they're all great. They're all fantastic. So I let them go. They can have the big ones because the big ones are pure gold content. But I search for these ones that, no one else sees. They just sort of fall through the cracks, but they're still darn good. They really are. I love them. So today I missed the big ones. I missed them. I liked watching them, but today I went and I watched the big ones. And I did record a tiny bit of Judge Simpson, and I don't even know if this microphone is picking it up, but my neighbor kids are outside screaming and swearing. They're little kids and they're out of control. But don't worry, they'll be gone in a second. And this is like the 30th time that I recorded this video today. Try to get this, and I'm not starting again. So here we go.
Miss Seawright, you've been charged with simple battery. That bond is $1,000. Public indecency is $2,000, so your total bond is $3,000.
Total bond, $3,000. Doable. Not great, but doable. But we have two ends of the spectrum in this clip again. Different from the other day, but still the opposite ends. We have one person who, if you don't talk to the judge, when they ask you a question, your bond is going to reflect that. And then we have the other side of the spectrum. When you keep talking to a judge, when they don't want you to talk to them, your bond is going to reflect that. So here we go.
You have special conditions. You can't have any contact with Mr. Burton. And what's Mr. Burton's first name? Miss Seawright, what is Mr. Burton's first name? Can she not hear me?
She can hear you.
Oh, okay. Well, in that case, let me change the bond amount. Your bond on simple battery is now $5,000. Public indecency is $2,000. Your total bond is $7,000. Take care, ma'am.
No.
Court. Okay, yeah. See, should have put it before me. Anyway, I won't do that. Court does call the case. People versus William Matthews.
Alexander on behalf of the people.
And Alex Warren Green on behalf of Mr. Matthews.
And I bet there's better Simpsons from today. I know there is. I think Kelly, is he in Simpsons court? Kelly, the evil guy. Ugh. He might be in there. I didn't want to get that. So I just got this clip from Simpson, and I'm happy with this clip. This clip makes me laugh a lot.
Mr. Matthews, could you please state your name?
William Vernon Matthews Jr.
Thank you. Your Honor, I did receive the competency report in this matter. I reviewed it with Mr. Matthews. We have no objection to those findings and the admission of that report.
Okay. People stipulate to the report?
Yes, Your Honor.
All right. Based upon a review of the report, the court
And Your Honor,
would find that the defendant is competent to stand trial, which specifically indicate that the defendant understands the nature and objects of the proceedings against him and can rationally assist in his defense, and therefore the defendant is deemed competent. All
It's
right.
not.
So, counsel, where would you like to go from here? First of all, counsel, you need to make sure that you send me the orders, please.
I will make sure I do that, Your Honor. From here, we're requesting a preliminary examination.
This poor attorney is just going along like nothing's wrong, and he's about to get slapped right upside his head.
Did we want to address his bond or his motion?
Your Honor, if I may, we actually last PCC with Ms. Gaines, the court found the defendant competent and Ms. Gaines sent over the orders. And then I also had sent over the violation to Ms. Gaines and the court while we were on the record, and we adjourned to have the violation hearing.
Correct. And you're right, Ms. Kirby, and I'm sorry I missed that when I opened the file. But,
yeah, Miss Kirby is always right.
so he's already been found competent. You want this, so there's a violation hearing that needs to be held, but also, I don't know if counsel's aware, it seems Mr. Matthews on July 26th then decided to write to the court. And has, I guess, filed his own motion. I don't know if you've looked at it. Just the opening paragraph says that he believes the court has abused its discretion by enforcing the PPO and aggravated stalking charges, and that they violates his First, Fifth, and 14th Amendment constitutional rights. And then it says, it seems that the judge in this case, I'm presuming that it's me, disagrees with the interpretation of the Constitution. So, do you wish me to set that for a motion also? I mean, I don't know what you want me to do, counsel.
Your Honor, I did not see the motion filed ex parte. I would, if Mr. Matthews,
there's a whole lot more there.
I would like to review that, Your Honor.
I just read the introductory highlights of what I'm doing.
Thank you, Your Honor. And
You're welcome.
Mr. Matthews would like a hearing on that. I would be asking for a hearing on that. I'm asking for an adjournment of the bond violation hearing, perhaps to that preliminary exam date, because I reviewed the report in that. I'm not sure if new charges are going to be brought with respect to the bond violation allegations.
That's the greatest lawyer. You just like deflect, deflect, deflect.
So what do you want me to do, counsel? I will make sure you get a copy of this, both sides, so we know what we're arguing over. You want me to set this for a bond hearing, or do you want me to, the bond hearing in the motion, or do you want me to set it for a preliminary exam?
Your Honor, I'll ask for an adjournment of the probable cause conference, and I'm asking for adjournment of the bond violation hearing and to set a motion hearing on that same day.
All right.
And Your
So
Honor,
yes.
would the court like a response on the motion?
Which motion? His motion?
Yeah.
Do you have a copy of it?
No, we do not, Your Honor.
Oh, okay, but go ahead. You can respond
Oh, like
briefly.
a written response.
What?
Like a written response.
Oh, you want to write something?
Not me.
Yeah, sure. We'll take that. As I look at it, I don't notice you should spend a whole lot of time. I think I can dispense with most of it, but yeah, we need something in writing. So we'll set his bond hearing, his probable cause conference, as well as the motion. What should we call it? I'll just call it constitutional violations.
Constitutional violations.
We have it set for already on the 24th? Oh, we have other ones set on the 24th. Oh. Okay, so we'll set the motion on the constitutional violations, his bond hearing, as well as probable cause. We'll set that for August 24th, 2023 at 3 p.m. His bond at this time will continue, and I look forward to the people's response. All right, thank you.
Your Honor.
Thank you. File 22-6521.
So this guy, okay, this is the best audio this court gets, just so you know. This guy has the best defense against what the judge, now we know this judge, and when this judge says that, you know, I could put you away, he means it. Like, he's not playing around.
1H. This is up for the docket call at the two show causes with the precinct dates. Because where we at on the underlying charge for right now scheduled for we're second back up on September 25, 26.
Yeah, I think we're still there. In regard to the show causes, it appears that my client has had some sort of mishap with the soda. He is blowing, but he's blowing too early, which is causing, and I'm more than happy to put him on the stand to explain what's going on. He's showing me all the documentation.
Well, that's the least of the things that worry me about Mr. Vanier. Mr. Vanier, it's alleged that you're in contempt of court for violating your bond for not just late and missed sober-link tests, but by my count now, between the two show causes and some additional violations you sent to your lawyer, positive alcohol tests on the sober-link on June 22nd, on a drug test, positive ETG, June 21st, June 9th, June 27th, July 6th, July 11th, July 20th. We're going to have a hearing on those allegations where they need to be proven. If I find you being contempt, I could jail you for 93 days, fine you for $7,500 in both. If you're not complying with the terms of your bond, I can revoke the bond as well. And Mr. Gilbert, do you know Mr. Daniel want a hearing on those allegations?
I would request a hearing, Your Honor. I'll maybe dig into those.
Okay, so I think what we'll do is he's still on the backup for that trial. We'll have him come for a docket call and bond violation hearing on August 29th, so that we can see them. We'll set that at 1:50. And really, that's actually the same time as Mr. Blackburn, and they're both actually got same trial. So I don't know if they're going to make them flip for it, or but we'll have to decide which one is going forward for trial and which one's going to get an alternative date. But I guess, Mr. Vanier, this is an alcohol-related offense, and it's alleged that now I've got 1, 2, 3, 4, 5, 6 positive ETG tests, 2.
But okay, he has a lot, but he has a defense. He has to do it.
Positive sober links for alcohol. I'm revoking your bond. You're remanding the sheriff.
In my medical report, the doctor's report I dropped off.
Yeah, I know. You came and told the staff the doctor says you have to drink. That's baloney. So if you want to bring a doctor to come to a hearing and tell me that you have to drink for medical reasons, I would love to hear it.
For the sake of my life.
Okay, well, I can't wait to hear that. I can't wait to hear that testimony. See you August 29th at 1:50.
I feel like getting my doctrine just so that I can screw with the judges and go in and say, yep, he needs to drink or he's going to have a stroke.
Okay. You can make some phone calls on that.
And see, we have one case at the Arc, it looks like. Is that right?
So, okay, we're here for the guy down in the bottom left right now. That's what we're here for. But sort of pay attention to the girl in the top middle. She does not want to be in front of this camera. And throughout this whole docket, I didn't record it all, but throughout this whole docket, she dips. She keeps dipping and then crawling away from the camera. And then they'll come into the room and they'll pull her back in front of the camera. And then she'll be there for a few minutes. And then you'll just see her slowly sink down, down, down below the camera and just dip away. And it's so funny.
Yes, Your Honor. If we may
That is
with Ms. Gwally first, because I'm finishing the documentation for the ARC. There's difficulty with reaching clients at the ARC prior to court today, so we had to do the breakout rooms. I apologize for being late, Your Honor.
No problem. So we'll start with Mr. Brown, who has already introduced himself to me. Mr. Brown, did you have a chance to go over your constitutional rights with Ms. Cameri? Mr. Brown?
I'm not sure, no.
Cameri, did you go over your
Mr.
constitutional
Brown?
rights?
The better question would have been, Mr. Brown, exactly how high are you?
Mr. Brown,
Mr.
can you hear me?
Hello?
Yeah, can you hear us?
Yeah.
Okay, so did you go over your constitutional rights with Ms. Cameri?
Is that my attorney?
Yes.
I
Did you go over
believe
those
so.
rights?
Yeah.
Any questions for me about those rights?
No.
Thank you. And your address is 1.
Look at me go.
It's a mailing address. Yeah.
Okay. Do you have a cell phone number?
Yeah.
Yep, I did it.
Thank you. Ms. Cameri, is there a stipulation of probable cause today?
Your Honor, the defense stipulates probable cause for purposes of today's hearing only.
Okay, thank you. We'll note stipulation of probable cause on charges of obstructing a law enforcement officer in the performance of the officer's duties and possession of dangerous weapon. Enter not guilty pleas for Mr. Brown to those charges. And is Mr. Brown going to hire counsel or seek appointment of counsel?
Mr. Brown is requesting appointment of counsel. He currently makes approximately $800 in 1 month, and he has expenses that exceed that amount.
Okay, thank you. I will appoint counsel to represent Mr. Brown. Counsel in this case will be Ms. Langley. Mr. Brown, I'll order that you pay $50 up to freight taxpayer expense of providing Ms. Langley's services. And Mr. McClellan, city's position on release.
The city's asking the court to consider some bail, $1,000 each count, total of $2,000 cash or bond, and that's factored in based on the active warrant out of City of Olympia. It's also noted in the report there was a DOC warrant at the time of contacting Mr. Brown. The applications essentially, he was at a Planet Fitness. They were trying to get him to leave. He locked himself in a bathroom for about an hour.
That's what I do when I go to Planet Fitness. I tell everybody I'm going to the gym and I lock myself in the room for an hour.
Law enforcement responded a little after he left. And once they found Mr. Brown and placed him under arrest, the possession of a dangerous weapon involved brass knuckles in his backpack. But given those other prior warrant status, the obstructing also involves initially giving a false name before being identified. So there are some concerns about him interfering with the administration of justice without some more heightened conditions. So I'd ask for the $2,000 and then no contact with Planet Fitness, no criminal law violations.
Is Planet Fitness the new Walmart? I don't know. It seems like it.
Thank you. And Ms. Kamiri?
Your Honor, I request that Mr. Brown be released on his personal recognizance today. He has an appointment with the Housing Authority on the afternoon of August 16th. He needs that appointment. He needs to make that appointment in order to set up housing for himself. If he remains in confinement, he'll also lose his job. He has access to reliable
There she goes. She dipped the person in the top.
Transportation to ensure that he'll make it to his next court appointment. And he understands that he needs to get his other warrants quashed as soon as possible upon his release.
Thank you. Mr. Brown, what do you do for work?
Labor.
Say that again?
Labor.
I can't tell. I keep trying to tell. I think the other inmate in there is re-asking the questions that the judge is asking so that he hears them. Now, it could be an officer out of camera view, but someone else is in there that keeps re-asking the questions because he doesn't answer the judge.
Warehouse working.
Yeah, gotcha. Who do you work for?
Labor Works.
Okay, yeah. So it's temp work?
Yeah.
Okay. If I let you go, you're going to come back to court?
Yes, Your Honor.
Okay, sure.
Why'd you miss that Olympia hearing?
Which one?
That's a good question. The most recent one that you missed, which was back in April.
Will I be hearing back in April?
Yeah, you missed I see you missed a hearing in December, you missed a hearing in October, and missed a hearing on the 17th of April. Actually, sorry. And then you missed another one just yesterday.
So is this for district court, like the courthouse too or something? And
this is for the city of Olympia Municipal Court. So you've missed 4 hearings with them.
What is this, like court?
It's for your, in a second. Your charges of violating the contact order and malicious mischief. So that's the case that the warrant's issued for.
Okay.
So your reason for you keep missing hearings down there?
No, I remember I was supposed to go to I think around this week. Actually, I was supposed to have an appointment with my probation officer.
Okay.
I don't know about the hearings, like in court, like if I have a court meeting, if there's like mailing to my mom's mailing address, because I don't have housing, I'm homeless. That's why I'm trying to get out for an appointment next week with the housing agency.
Ms. Kimmery, do you have any, did you have any issues of competency in your conversation?
No, Your Honor.
Okay, maybe it's just difficulty hearing.
No, it's competency.
All right, Mr. Brown, I am going to authorize your release. You are to not go back to Planet Fitness. You're not to have any criminal law violations. You're coming back to court on Monday, the 18th of September.
No, he's not.
8:30 in the morning. Ms. Langley is your attorney. The jail will give you contact information from Ms. Langley, and I want you to give her a call sometime this week or next week so you can talk about the case and you're ready to go when we come back on the 18th of September. If we don't resolve the case on that date, we'll be setting it for trial. You understand all that?
So I have an appointment next month on the 18th?
No, on 18th of September.
18th
That's
of
next
September?
month.
Yeah, and you're going to have a document when you leave the jail that has that date on it, and we're going to be sending text notices to your phone telling you about that date.
For a court date?
So, I expect you back on the 18th of September.
Is this at the courthouse too or municipal jail?
It'll be at the courthouse.
The Lake Ridge Drive?
Yep.
Okay.
Okay, 18 September, 8:30 in the morning. We'll text you notice, and you're going to walk out of jail today with a notice that tells you that.
Okay.
All right, thank you.
Thank you.
This is Washington. And again, Washington, they don't like to put people in jail.
Taking responsibility for our actions today.
So I didn't get her whole case because it doesn't matter. I mean, it's not that great. But this little exchange that she has with the judge right here is golden. So I just kept this little bit in.
Extremely early in the process. She understands that what she did wrong. She wants to be able to move forward. And so we'd ask that you sentence her a minimum amount of jail time to allow her to do so. Thank you.
All right, thank you. And Ms. Camiri, or pardon me, Ms. McCauley, anything else you would like to say?
If I could just do 20 days, that would be really cool.
Okay.
That's all I have to say. But
Oh, wait.
I plan on going to treatment and changing my life.
If I could just have 20 days, that would be cool. Oh, and by the way, I'm changing my life.
That's what my objective is.
Good. Yeah, I was going to say it'd be really cool if you stopped stealing.
Yeah. I really actually want to go to treatment.
Okay. So this is all drug related?
Yeah.
All right. Well, I hope you listen to your words and I hope you take action on your words. That would be good. I bet you're getting really tired of this lifestyle.
Yeah.
Just in case you wanted to know, she got 30 days, not 20 days.
All right. Are you ready on the Nisqually one before we put you in the breakout room with Mr. White?
Yes, Your Honor.
Okay. And Nisqually, your name, please? I'm muted. Do they have to unmute out there? Okay, so out of Nisqually, it's muted. We had it muted because of Mr. Mercer, so if you unmute for us, please.
I know. Usually when they have to mute for someone, that's really good content and I should have gotten it. But really it wasn't. Like, he had a hearing with the judge, and then as he was leaving, he started saying a whole bunch of stuff, but none of it was really that bad or funny or whatever. So I left it out.
There we go. Sir, your name?
My name is Scott Gamazel.
Thank you, Mr. Gamazel. And Ms. Kamari, what are we doing in Mr. Gamazel's case?
Standing for trial, Your Honor.
All right, thank you. And I don't show that we had your cell phone number, Mr. Gamazel. Do you have a cell phone?
No, sir.
Okay.
I've had several cell phones over the last few months, and each and every time they get stolen from me, I'm a homeless man, and homeless men get things stolen from them every day.
Yeah, that's what I hear.
It's true.
Yeah, the reason I asked is because if you have one, we use it to send reminders of court hearings, just make it easier.
If I may, I would like to recover a cell phone and use an old number that I had back in the day. It's 425-478-5695.
Yeah, I didn't mute that out because that's not his number. And the way he thinks cell phones work is just not the way that cell phones work. And you'll hear he gets more detailed into it. So that's just never going to be his number.
Okay, so we'll send notices to that phone if you think when you're out you're going to have possession of it.
They're going to send notices to that phone anyway.
I will do everything. I own two phones that are guaranteed by the Boost Corporation. I picked them up on College Street in Lacey, and so because they're guaranteed, because they're under warranty, I should be able to get that taken care of.
That's not how that works.
Great. All right, we'll set the matter for confirmation and trial, and looks like we're running speedy trial through the 24th of September. So those dates will come up sometime in the next 6 weeks, Mr. Gamazel.
Okay. And in the meantime, I have a number of places that I can stay with friends and family, and I would like to be released from custody immediately. I don't want to.
It looks like you still have an active warrant out of King County.
I'd be glad to take care of that when I'm out.
All right.
I have resources. I have almost $7,000 in.
He has $7,000. He just said it, clear as day.
Social Security disability income that I haven't been able to access because of a lack of ID and a lack of a bank account. But those are circumstantial situations based on the fact that I am a homeless man, and I've been homeless ever since I was kicked out of my home by my ex-wife.
All right. Thank you, Mr. Gamazel. It looks like Judge Meyer imposed the bail back on the 26th of July at $500 cash or bond.
I have no money.
I have no money.
As far as a bail setting goes. So at this point, I don't find conditions are such that I should review Judge Meyer's decision. Just leave that in place, but set the matter for trial. Thank you, Mr. Gamazel.
Okay, when it comes to my status, I would like to be released on bail
Right, yeah, and you have bail, 500 cash or bond, so you can post 50 and you get out.
I post 50, so all I have to do is have a family member deliver $50 to this facility and I can be out.
No, they have to arrange that with the bail company.
Explain to me. Okay, I'd like to get some assistance with that.
Okay, all right, thank you, Mr. Kamazel.
Thank you.
Yep. And are we
Judge
ready?
ignored him.
With that, any other questions?
Okay, this is shocking. Okay. I don't really know if the judge is allowed to do what she just did. So if you think about it, like globally, the judge's role in our community is to keep the community safe. That's what the judge's main role is. And that's what she does. But I don't know. I don't know. The more I watch this, the more I just don't know if this is legal. You'll see. Ew. Whew.
All right, Ms. Pimentel.
Your Honor will acknowledge receipt of the complaint, waive formal reading, and enter a plea of not guilty on his behalf.
Not guilty plea will enter. I have had a chance to review the police reports. I do not finding a probable cause. What is the city's request with regard to release and conditions?
Your Honor, I just got an email from Detective Sergeant Martin to request high bail of Mr. Pina Diaz for investigation on a homicide that happened in Baco. They would like to hold him for further investigation on that case. We understand that this is an unusual request, seeing that it does not have much other criminal history, but the officer, the detective involved in the case is in training and cannot be here today to give testimony on the investigation, or I believe he can't do it anyways because it's pending investigation, but they would like to hold him on high bail to investigate a homicide case that happened. I believe I got a 2022 case. I just got the email, so I wasn't able to look up the case itself, but the email plainly says that they want him held so they can speak with them about that case. I understand it's an unusual request, Your Honor, but that's my request. That's their request to me to request to the court.
Ms. Pimentel.
Your Honor, I'm obviously requesting the court release Mr. Pina Diaz. If detectives want to question him about another incident, they can do that at any time, assuming he's willing to speak with them. However, obviously that is not before Your Honor today. I don't have any additional information in regards to that. I don't know that we're in the business of simply just holding people in jail for other investigations that are unrelated to the reason that he is before the court today. So I would ask the court to impose standard conditions, release him pending an out of custody date. He will need conflict counsel appointed. It indicates he was working. Sounds like based on the amount of money he's making, he would likely still qualify for counsel. But my office has now been appointed to the co-defendant.
Right. So, Mr. Lohr, in the police reports, the officer noted concern for the safety of the community in relative detail. I guess, and Ms. Pimentel is correct, I'm not going to hold him on an investigation, but are you indicating to me concern for the safety of the community because you believe he has a violent allegation pending as well?
Yes, Your Honor, that's correct.
So he is a suspect, he's not just a witness.
He's a suspect, him and Ms. McGallen, and I unfortunately, Your Honor, I got the email after she was arraigned and PR'd. The sergeant did request that they both be held due to a shooting that they were involved in. They are, yes, they are suspects and not witnesses. And, Your Honor, just to supplement the record a little bit, they were arrested and discharged for gang-related graffiti's, and the officer or the sergeant believed that the shooting that happened that they're being investigated on was also gang-related shooting.
All right. All right, Ms. Pena-Diaz, the easy part is Ms. Pimentel's indicated she believes that you would qualify for court-appointed counsel. So based on that representation, I will make a preliminary finding that you do qualify for counsel and appoint conflict counsel. With regard to that, you will need to complete an affidavit for me that asks about your income, your assets, and your expenses. Without that document, I don't actually have a legal basis for granting you court-appointed counsel, and I might have to reverse my decision and charge you attorney's fees, which I'm pretty sure you don't want to have happen. So please get me that affidavit. With regard to the city's request for bail, it is a very unusual situation given your complete lack of history. However, the officer dictated or set forth in the police report the concern with regard to the increase in gang activity in the area, and in particular violent gang activity, and that documented fairly well in the narrative with regard to the reason for the concern of gang affiliation, and that the tagging was gang related. Based on that and the allegation that you may be involved in a very serious violent offense, I do have concerns for the safety of the community, albeit odd with the charge, and I will set bail in this matter. I will set bail at $100,000, given my concerns for the safety of the community. Should you post bail, you will need to appear and follow the following conditions. You need to notify the court in person or in writing of any change of address, have no new criminal law.
All right, that's crazy. What just happened? Shocking, shocking, shocking. He is in here right now for tagging, which is just spray painting a building or whatever. He just got $100,000 bond in front of a judge for a spray paint.
Violations for which there is probable cause. Make an appointment with your attorney, make it to that appointment. They can't help you if you're not talking to them. Make it to your court dates. I'm going to set this matter for August 18th at 9:30 in the morning. For pretrial, trial will be in the September trial term. No, I'm sorry, in the October. I know we need to set it in the September trial term. Your attorney will be, it looks like Jamie Kim, as that's the next one up in the presentation. So we'll get you her contact information. Ms. Pena-Diaz, I don't know what's going to happen. I expect that before that date, sometime this week, I would like to have the city document their request, and Ms. Pimentel or Ms. Kim wishes to have the matter set for a reconsideration of bail. I will allow for a short set to do so. I am relying on the city's representation from the detective. I understand that the detective involved is at a training. I expect that this is important enough that that detective will provide documentation to the city as quickly as possible. With regard to the Magayan matter, I am going to recall that at this time based on the information that has been provided. So I will have her brought forward now.
And Your Honor, I'm sure Ms. Kim will do the same, but I would just renote defense's objection based off of the facts that are before the court, specifically that the allegations involved here have nothing to do with anything violent. It is in fact just what Your Honor represented, which was a tagging. There was no additional representations of anything violent, nor police that we are aware of, or the information that is before the court today has any indication that they've been involved in anything. I mean, we don't have any additional information. So this is, Your Honor's going off of what a detective may or may not be saying. We have no additional information. So defense is renoting the objection. Will be the same thing for Ms. Magayan. Without anything further today, I don't think the court has a basis to hold either of them on the potential of suspicious activity that we don't know anything about. Or we're going to be really in a slippery slope here moving forward.
I understand your objection, and they are noted for the record.
That's crazy. That's crazy, crazy, crazy.
So that will conclude this matter. We'll have Ms. McGuinn's matter brought back.
Thank you. Your focus.
Okay, so let's just think this through real quick. Because this is crazy. All right. The judge's duty is to protect the community. Got it. Okay. But, you know, I don't think she can do what she can do. Unless. So is the judge allowed to set no bond on anything that comes before her? Is there a cap on the amount of bond that a judge can set on a specific crime? So if you're just tagging, is there a law? Is it in the Constitution that says the judge has a limit to the bond that you're allowed to set on this crime? And is the judge allowed to set no bond on any crime? So if that's the fact, if the judge is allowed to set any bond they want on any crime, then she's fine. And then also, when we look at other court cases, we see that the judges go back and look at what's going on in people's lives right now. So if there's an allegation, if they were charged with a different crime, even if they weren't convicted and found guilty, if they were just charged with another crime, the judge is allowed to look at that when they're thinking about bond for what is in front of them. So, you know, if they had a DUI on Tuesday and then they were picked up on Wednesday with meth, they're allowed to look at the meth when they're talking about bond for the DUI. They do it all the time. So if that's the case, then yes, she is allowed to look at a murder when someone's in front of her for just tagging. However, there's no possible constitutional way that you can hold someone in jail for $100,000 because of tagging. And that's all that's in front of her today is tagging. So I don't know. I'm on both sides of the fence here because honestly, I'm not a lawyer and I should be, but I'm not. So I don't know what's going on, but most of the lawyers don't either. So I would be a fine lawyer. Instead, I'll just watch them on YouTube, and then hopefully there's some lawyers that are watching this and they can just like comment for a second and let us know if this is like outstandingly unconstitutional or yeah, she's well within her limits.
Good morning again, Ms. McGuinn.
Good morning.
Since we had your hearing, the city has indicated they've received additional information. Mr. Lohr?
And that's correct, Your Honor. We have a sergeant who has requested that Ms. Ugaya and Mr. Pina-Diaz be held on high bail to their involvement in a shooting in 2022 in Everett, a homicide, actually, and they would like to hold them both for further investigation. The city believes that it was the email indicated it was gang-related shooting, and what Ms. McGuire was booked on last night was gang-related graffiti.
All right. As I previously indicated with regard to Mr. Pina-Diaz, that the officer's report in this case did document the concern for safety of the community based on the fact that the tagging that was being done was gang-related, and did well document how that is a threat to the community, especially given the recent uptick in gang activity and violent gang activity in the area. based on that information, I have on Mr. Pena Diaz, I did set bail, and on Ms. McGuyan, I am going to also set bail in the amount of $100,000. Should you post bail, Ms. McGuyan, you will need to appear for court but I'm going to set the new court date to next week on the 17th of August at 9:30 in the morning. All right. So with that, we'll see you next week. And Ms. Pimentel, your previously stated objections are noted for the record with regard to the court having considered, but I would indicate that the information before me is that they are suspects in a homicide, which is simply the only thing I am taking into consideration here. So.
Don't worry, I'll be watching next week. Do not worry.
All right. So that's it. That'll conclude this matter.
I love her. I love her. And I'm on her side on this one. I think she's right because she does this every day. She sees what happens every day for many years. So she knows. She knows what goes on.
Wade, Mr. Deeks, you've been charged with a second-degree felony fraudulent use or possession of identifying information. The range of punishment on that type of offense, sir, is a minimum of 2 years to a maximum of 20 years in the Texas Department of Correction and a $10,000 fine. That bond has been set at $20,000. Do you have any questions, sir, regarding your charge or bond amount? Are you requesting? They say you refuse to be interviewed. What do you mean? I won't qualify you if you won't interview.
Nobody interviewed me. They threw me in the chair and put me straight upstairs.
Yeah, that's not what this says. So they say they tried to interview you. You refuse to answer the questions. Do you want me to send them back?
Yeah, nobody talks to me. I'm telling you, they threw me in the chair, threw me straight upstairs. I've been here for 4 days.
Yeah, you may not remember, sir, but okay, I'll send them back.
4 days. I remember everything.
Requesting that I appoint you an attorney this morning to help you with this case. You want me to appoint you an attorney?
Yeah.
All right. So when they come back, sir, wake up, answer all their questions so we can see if you qualify, okay?
I'm still not telling you, ma'am. I've been here for
24 years, okay? I'm the carpet, I'm the drapes. They interviewed you, and you refused. But I'm going to send them back.
Nobody interviewed me.
Okay, I'm going to send them back. I'm going to be nice. I don't have to do that, but I'm going to send them back to see if you'll qualify, all right? When they come, talk to them, answer their questions so we can see about getting you out of here. Thank y'all for your service. Take care of yourself, sir. Next, we have Mark Elizondo.
Patrick Agnick. I appear on behalf of Ms. Robinson.
And now we're back to the other side of the spectrum. So before we had someone who just wasn't talking at all, bond reflected that. Now this isn't a bond. This case isn't a bond. And everybody tries to help her. They try so hard to help her. And she just makes the very wrong choices and thanks them for giving her the maximum amount possible. She walks out of here with the maximum amount possible. She did it to herself. And you can see Meineke gets a little irritated in the middle and then just goes for it. He's like, fine.
By video. Ms. Robinson, can you say your name?
Kelly Harrison Robinson.
Thank you, Judge. Prior to proceeding, I know this matter's been up a number of times. There was issues with Ms. Robinson's non-appearance. She did take the efforts to get the matter reset.
Okay, and I should prepare you that her audio gets bad. I'm sorry. Her audio gets bad, so Judge Meineke hops right on it, turns off her video to try to make it better for you guys. Because Meineke knows that people who consume my content do not like bad audio.
There's really no plea offer in this case. They are willing to dismiss the civil infraction, but the offer would be that she tender a guilty plea to the 2 charges. Her request before the court judge would be straight fines and costs. It's just a request. Certainly that's to your discretion. What would the court consider doing in a case like this? She does have a prior criminal past. She explained to me that it's been a number of years since she's last been in trouble.
14 years. I wanted to
Kelly,
ask.
hang tight. Let's see what the judge has to say.
Oh, she's mad. She does not want to be quiet. She is. She's breathing through it. Just breathe through it, Mama. Breathe through it.
I mean, I would say it's true that it's been a while since Ms. Robinson has been in trouble. That helps. I'm concerned about what she had in her possession based on.
I don't know why his S's are killing my ears right now. I don't know.
On the plea. I also wonder why, since she's been eligible to get a license for years and years and years, why that hasn't happened. So, I mean, I guess those are some of my questions that I would probably need answers to, because she's been eligible to go get a license since.
Yeah, that's what I wanted to bring up.
2010. So, have you tried?
I've tried, and money's been an issue. I was turned down after I passed my assessment and everything. I did everything, and they said because I got all of my letters notarized by the same notary, which they didn't say I couldn't do. They were handwritten and typed. They didn't like that they were typed and signed. It was just a bunch of reasons that made no sense to me.
Right, but that's 14 years ago, right?
That was like 12 years ago, and I paid a lot of money to do that.
Okay, well, hold on.
100 and 400 and another 400 a year. That's everything I did. And I just gave up hope after that. And it's a lot of money to go back and do that. And I finally found somebody.
Okay, now I'm going to tell you guys what I just told her. Breathe through it, Mama. Breathe through it. The audio got bad. Meinecke's going to fix it.
Actually recently, I really gave up hope. I just, after so long, and after being turned down, I just got mad and gave up hope. I recently did find somebody though that said a counselor and that could do my assessment and my act as my counsel and for a really good price. And I'm looking into that now, so I'm excited about it again, I guess I could say. But yeah, it's been a while. I'm looking forward to it. It's been a long time.
I mean, in theory, Ms. Gagnick,
you mentioned a program one time. I worked with you also.
Right, that's where I'm. So hang on. She would seem to be perhaps an Operation Drive candidate, Mr. Gagnick.
Judge, I'm explaining to her every which way I think what the court realistically would consider for something like this. What it comes down to, Ms. Robinson needs to make that decision. If she's willing to do Operation Drive, I'm sure it's going to come with drug testing, and that's something that she doesn't want to do probation.
Well, here's the reality that Operation Drive in this circumstance, the drug testing would be outside of the court. Like, I'm not going to order drug testing. That's going to be part of her substance abuse evaluation that she has to do in the part of getting her license back. So, but if she's not, the reality is, Ms. Robinson, if you are still using, all right, they're not going to give you a license. So we're just, that's the reality. So, if that's still.
For drunken driving 14 years ago after leaving the bar.
Breathe through it, Mama.
And I don't drink. I haven't had a drink in years. I don't care if I drink. I'm older now. I'm partier. I don't like the way it makes me feel.
Hold on one second. Hold on, everybody. Hold on.
My hero. Go, Meinecke, go. Fix that audio.
Okay. So Ms. Robinson, are you still there?
Yeah,
You're in and out. I can barely hear you, ma'am.
I'm here, but I don't see my face.
Well, yeah, I shut down your video because your audio was breaking up, and sometimes by doing both audio and video, it breaks things up. So I should.
Thank you. I'm here.
Okay. All right. So I can't, Mr. Gagnon. This is, I have no.
I found somebody that for my assessment and my counsel, and I would love to go ahead and do that. I come through him.
Kelly,
Excited about it.
Kelly, let the judge finish his thought, okay?
That interruption did her in. That was when Judge Meineke said, okay, enough. And we all know when a judge says enough, they mean enough.
Sorry.
So I don't think I can go forward with the fines and costs sanction, all right? But if I'm not putting her on probation and I'm not putting her on Operation Drive, we're talking about probably $1,500 in fines and costs. It's going to be maxed out on both because that's the only sanction that I have for driving on a revoked license and for having controlled substance paraphernalia. And she doesn't have a ton of money. And so that doesn't really make a ton of sense to me because I don't want to continue to put Ms. Robinson down deeper and deeper in debt.
I recently found a job that would be a problem.
What's that?
I recently found a job. I have 2 offers. That wouldn't be a problem.
Okay. All right, Mr. Gagnon, I think.
Can we reset the date?
No, let's go forward with the plea. That's fine, and I can go forward I'll go forward with fines and costs, but they are going to be substantial. And I just want to make sure that we're all on the same page. I'll give her time to pay, but I think we're sort of running into a brick wall, and it's just not going any further at this point in time. So
I'll leave it at that. Ms.
Robinson, I'm not going to put you on jail. I'm not going to put you on probation, but I'm not going to give you a break in fines and costs. I will give you time to pay.
Thank you. I appreciate that. Thank you.
Okay. Please raise your right hand. Swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir. Yes, Your Honor.
All right. Go ahead and put your hand down. Ms. Robinson, can you read, write, and understand the English language?
Yes, Your Honor.
Can you hear and understand me?
Yes.
All right. Have you had a full chance to discuss this with your attorney?
Yes.
Are you satisfied with his advice?
Yes.
All right. You're pleading guilty to driving while license suspended and possession of paraphernalia. You should know that by pleading to the driving while license suspended, that will add another 1-year revocation to your license. Before you enter a plea, you should understand you have the right to represent yourself or be represented by an attorney. If you cannot afford an attorney, one will be appointed for you at public expense. You have the right to a trial, either by me or by a jury. At that trial, you'd have the right to confront, cross-examine, question all witnesses brought against you. You'd have the right to have the court subpoena witnesses on your behalf. You'd have the right to testify if you wanted to, remain silent if you wanted to, and no one could say anything about you remaining silent. As you appear before this court, you're presumed innocent of this charge, and your guilt has to be proven beyond a reasonable doubt. Ma'am, do you understand that once you enter a plea, you give up all those rights that I just said that you'd have at a trial?
Yes, Your Honor.
Once you plead guilty, there'll be no trial. You understand that?
Yes.
Anybody promise you or threaten you in any way?
No.
It's your own choice to do this?
Yes.
All right. December 11th of last year, 2022, were you in the city of Royal Oak?
Yes.
All right. Were you driving a motor vehicle on Stevenson and 12 Mile?
Yes.
Was your license suspended?
Yes.
Okay. And did you have possession of drug paraphernalia at that time and crack pipe?
Now I know yes.
Okay. Hold on.
Yes.
Is that a yes, ma'am?
Yes.
Okay. Satisfied, Mr. Gagner? Hope you're on mute. You're on mute, Mr. Gagner. You're on mute. You're on mute.
Judge Reicher, to be clear, I've discussed the matter now with her a number of times. The decision to go forward today as charged, that was her decision based upon her unwillingness to be placed on probation. So it was her decision today. I explained to her her right to a trial. I am satisfied with the plea, assuming that she is satisfied. I'd ask the court to consider fines and costs.
Okay. Anything you'd like to say, ma'am, before this court imposes a sentence?
I really appreciate it very much. I have a good job opportunity, and I'm looking forward to it. Thank you. That really helps. Thank
Sure,
you.
okay.
Okay.
Okay, so just think back over everything that just happened to Meineke. She kept interrupting his train of thought. Her lawyer kept interrupting her. Her audio was bad. And then this other woman comes into court and she starts making noise right away. So he's at his limit. He is at his limit. And everybody in this, all these lawyers saw that. The ones that were there anyway. They saw it. Even if you don't see a lawyer in the boxes on the screen, they're still there. They can still hear. They're still participating. It's possible some of them just joined and didn't know this, but I doubt it. I bet they joined at the beginning of the docket and they heard everything that was going on because they're listening for their case. So they know that Meinike's at his limit. So what they do next is uncalled for.
All right, it's a sentence of this court on the driving on a revoked license. It's a $500 fine plus $500 in court costs and $125 in state costs for a total of $1125. On the drug paraphernalia charge, it's a $75 fine plus $75 in court costs and $125 in state costs for a total of $275. The grand total will be $1,500. I will place her on a payment plan.
Thank you.
And obviously, you'll need to contact the court to set that payment plan up. Ms. Robinson, obviously, if we don't get the payments, the court will issue bench warrants. Just if you do fall behind on payments, give us a call. Good luck.
Thank you. Thank you.
Okay, everybody needs to just leave him alone for a second. Nope.
We've resolved the standard.
Yeah, Mr. Magginson, I got a couple others.
We're on.
Yeah, I got. Hang on, everyone. I appreciate it. I had to deal with that one for Mr. Gagnon, who's been here waiting. But I'm going to go through. I've got my files now.
Poor guy. All right. I didn't get this whole hearing because it's not important. I just cherry picked the best parts of it, and it is showing you that. There's echoes in this courtroom.
2223501. Counsel, state your appearances for the record, please.
Keith Robinson for the people. Roland Lind on behalf of Tyler Laux.
Sir, are you Tyler Laux?
Yes.
Thank you. And I've received from the Forensic Center, Department of Health and Human Services, Carroll Psychiatric Hospital, a report opining that Mr. Laux continues to be incompetent to stand trial, and as well an opinion of the treatment team that there is not a substantial probability that provided a course of treatment, he will regain that capability of participating in his own defense within the time limit established by Michigan Mental Health Code 330.2034. And counsel, are you stipulating to this report as the sole evidence for purposes of the hearing today?
Yes, Your Honor.
Yes, Your Honor.
Thank you. The court has reviewed the report in its entirety, prepared by Ann Wagner Spina, MD, Consulting Forensic Examiner, Carroll Center Staff Psychiatrist. I will not read the entire report into the record, but note that he still did not fully understand his charges or potential outcomes for a legal situation, despite this being the 5th meeting with this writer. And it is reviewed at each meeting. More importantly, he remains delusional about the circumstances of the alleged offense and his current legal situation, specifically that he is the president and that the Secret Service is involved in his legal situation. He did not have the capacity to understand the nature and object of the proceedings against him or to assist in his defense in a rational manner. Therefore, it is the author's opinion that he is still incompetent to stand trial and unlikely to regain competence during the time frame defined by statute. Based on that report, I will also find that he is incompetent to stand trial on all of these matters. There is a substantial probability that the defendant, if provided a course of treatment, will not attain competence to stand trial within the time limit established by law. Counsel, I've checked the boxes on all 3 of these orders. Let me find the third.
So that was it. That was enough. You heard enough. He's the president. So they didn't charge him because he's the president. So those are some good ones. Hopefully my muffled sound is a little better. If you made it to the end, then maybe it is. We'll see. Not, it's hard to get people to watch a whole video on YouTube. But I do appreciate anybody who comes to watch the videos. It's nice. I hope I can get the best content for you. I watch a heck of a lot of court cases to try to find these ones that work. And I have a new microphone coming in a couple days. And I got in big trouble for it. Lots of guilt. So this baby better work. Better massage my feet too for the amount of money I paid for it. But yeah. So yeah, I'm going to keep looking for some more court cases and I will be back later. See you guys. Have a good night.